I want to talk about a little bit about what I witnessed inside the federal court today, October 28th, 2008.
Anyways, I was screaming at the top of my lungs, "Don't kill me, don't shoot me, I'm unarmed, don't shoot me."
The trial, or not the trial, the sentencing of convicted Brown supporter Danny Riley. Of course, he wasn't so much convicted of being a Brown supporter as he was of some weapons and explosives charges and of allegedly trying to stop U.S. Marshals from arresting Ed Brown on his property. Riley came in, they started the trial about 20 minutes early, which was a point of contention for the folks in there who were observers, just people as opposed to, people from the government. Basically, when you go into a trial like this, there's the people and there's a bunch of government folks, and there's not a lot of in-between there, although in this case there's a little bit of exception. But the people who were there to kind of observe and were concerned about Danny's rights were upset by the fact that they had moved the sentencing from 11:30 a.m. to 11:10 p.m. 11:10 a.m. at the last minute. A lot of people ended up coming in late because of it. A lot of them said, well, it's not a public trial if you change the date and time at the last minute, or even if you just change the time at the last minute, especially if you make it earlier. I should probably rewind just a little bit as I explain some of this to you. In 2007, Plainfield, New Hampshire tax protesters Ed and Elaine Brown, an elderly rural New Hampshire couple, held the U.S. federal government at bay. They did this for about 8 months, they said they would open fire on any U.S. government personnel that came on their property. To try and take them away. They were people that refused to pay the income tax because they believe there is no law that says you have to pay. So once this sort of standoff began, people began trickling over to the Brown home in various numbers at various times. But there were probably 1,000 people that came and went from looking at some of the video over that 8-month period. Anyway, one of those was Danny Riley of New Jersey. A 9/11 truther, tax truther, sort of a guy that has a lot of unorthodox legal theories and other types of theories. And he was famous for this incident where he was out walking the Brown's dog during the standoff, whatever you want to call it, and was actually tased and fired upon by federal paramilitaries when he accidentally discovered them in the woods. I think for most of the period of time that this standoff went on, the Federals were not surrounding the house or anything like that. They may have had it under some surveillance or whatnot, but it was relatively unusual to run into any kind of federal personnel around the house, from what I understand. Well, anyway, the Browns, whatever their faults, whatever their unorthodox theories, received pretty excessive sentences. But the most excessive sentence of all was issued today, October 28th, against Danny Riley himself. And Danny was accused of, and I don't have the exact charges here. Well, we'll get to that in a minute here. It'll come up in its place with my notes. He was charged essentially with trying to create an explosive device and some other weapons-related charges. But anyway, he appeared, he walked into the courtroom. First the judge came in, and all the government personnel stood, and most of the people who were not government personnel stayed in their seats. Then Riley walked in, cuffed, dressed in brown, with a shirt reading Stratford County DOC. Some of the people at that point stood, the average citizens stood. I didn't stand for either Riley or the judge myself. I was probably the only one that didn't stand for either. Let's see what else. Riley immediately took an abrasive tone. He called the trial a fiction. I think it was the trial he was calling a fiction. Either he was calling the government a fiction or the trial a fiction, something along those lines. He tried to keep telling the judge he did not accept the man. There was a man designated to be his attorney. Riley kept saying, "I do not accept this man as my attorney." I guess he's like a federal appointed attorney. And then when the judge referred to him as a defendant, either the judge or the lawyer, Riley said, "I am not the defendant," or "I'm not a defendant." Then either the judge or the prosecutor began talking about minimum and maximum ranges of sentence. There's very little range. The minimum sentence was around 438, I think, months. Maximum sentence, well, no, that's not accurate. The government was asking for, the prosecutor was asking for 457 months sentence for charges I'll get to a little bit more detail here as I come across them in my notes. But Riley kept saying he was not a legal fiction, and he began making what you might call a straw man argument. It's a complex and unorthodox legal theory that carries no weight with the court and is hard for the average person also to understand. Riley said, quote, "You've been ordering me and enticing me into slavery," unquote. He said the judge should be sentenced to jail. He said, quote, "There is two Daniel Rileys," and he pointed out that one Daniel Riley is in capital letters and the other one is in lowercase letters, and he's not the one in capital letters, because I guess when you get government paperwork they almost always put your name in capital letters, so he's saying that's not him. Is this kind of thing true? Is there anything behind this? I have no idea. Apparently he believes this, but it's like I say, it's an argument that never carries much weight with either attorneys or the average public, and doesn't seem to have much effect on the government either. Riley said, quote, "I'm here under duress." He noted that he was shackled and that there were many armed men ready to pile upon him if they felt the need. He said the judge would owe him $50 million for something. I wasn't clear on what. He said he did not want to... no, that's something else. Hang on. He promised the judge some sort of envoys, like a bill. Of course, again, this sounds a little unusual to me. It doesn't make a lot of sense, but it is... You know, sending someone an envoy is a lot less violent than locking Danny Riley up and sending taxpayers the bill. Few people watching Riley would have found his arguments to be very sympathetic or compelling, but it's very important to remember that Riley does not force any of us to pay for his activities. Every government person in that room does force us to pay for their activities. So it's hard for me to get angry at Riley when he is not intentionally taking any of my money by force. Oh, by the way, I should point out that a lot of what I'm telling you here, they gave Riley the opportunity to make a statement, and I'm just sort of telling you some highlights of his statement, which went on for maybe 15 minutes.
This program is brought to you by FreeKeen.com. FreeKeen.com features audio, video, and blogs chronicling the transition to a voluntary society. FreeKeen.com also has comments and discussion forums so you can be heard. FreeKeen.com.
And I'm just sort of telling you some highlights of his statement, which went on for maybe 15 minutes. He said to the judge, quote, "You finally opened yourself to liability. How does it feel?" unquote. He said something that I think the average person could relate to a little bit more. He said the federal government was in bankruptcy. In the past, Riley has claimed that the federal government is run by international bankers. And again, there may be some truth to that if you look at how the federal government has handled the banking crisis and how it seems to be in bed with big banks. Maybe there's something to that claim. Riley also said, quote, "I'm not asking this court to show mercy because I'm not the defendant," unquote. He said he requested 66 witnesses and the government wouldn't let him have any. By the way, I asked government for responses on a lot of these stuff, and I couldn't get one. I'll talk about that later. He said video from the Brown house shot by federal personnel was doctored. There may be some truth to that. The video that I have of the botched raid on June 7th, where Riley was tasered, does go in and out of low resolution mode. There's a part of it, the most boring part is mostly in high resolution, and the interesting part that would be of use to the defense was mostly in low resolution. And there was, of course, some speculation that the feds were hiding some of the information by reducing the quality of the video. From what I saw, it's a little bit hard for me to show you on YouTube, but when I looked at the video on my editing software, the video, the high quality video appeared to be about twice as high of a quality, twice as high of a resolution as the low quality video. Riley brought up the issue of what he called helmet camera video. I didn't know anything about that, hadn't heard about that, and said he never got the helmet camera video from the people who raided the Brown home on, I guess, like around June 7th, 2007. Again, many of Riley's arguments, were not the kind that would appeal to the average person, but, in a free country, it's safe to have bizarre theories. It's safe to mouth off to public officials if you don't threaten them. It's safe to build your own weapons. And, in the 40s in New Hampshire, you could actually, you could buy dynamite from the general store. So if he's alleged to have attempted to, purchase explosive materials, then he's doing something that was completely lawful in the 40s and 50s in New Hampshire. That, of course, leaves another issue, though, the fact that he was alleged to have threatened to use these weapons against the government if they came on the Brown property. But again, no allegation was ever made that he had any aggressive intent with the weapons. It seemed as though even the government was saying his intent was defensive in nature. The judge said that there was some sort of a competency hearing to determine whether Danny is crazy, and I don't know. I didn't see that, and I don't know how that went. But the judge, that seemed to be a non-issue during this sentencing. The judge said he felt that Danny Riley was intelligent. He said he believed that Danny Riley considered these issues relevant. He said it's unfortunate his friends are urging him to jump off the cliff, and they are not jumping off with him. Although he wasn't saying they should jump off with him, he just seemed to be saying it was hypocritical for them to urge, allegedly, Danny Riley to make these weird arguments, and then that would get him in a lot of trouble, but not go make them themselves and get themselves in trouble. Let's see, what else? As complex and hard to understand as Danny Riley's conspiracy or whatever his theories may have been, the federal government's sentencing representations were probably just as complex and hard to understand. They used the term, they accused him of possessing a firearm, had convicted him of possessing a firearm in connection with a crime of violence. I think that's a quote. Possessing a firearm in connection with crime of violence. And I think they said there was a mandatory 30-year sentence for that, but I'm not clear. And of course, again, there wasn't actually any violence committed by Danny Riley as far as I know, and I don't think there's no charge that he committed any kind of violence. So, how could he be convicted of having, committed a crime of violence when he wasn't really? I mean, it's like he wasn't really charged with that. He was, maybe charged with making threats to use defensive violence, but no violence was ever actually used.
This program is brought to you by FreeKeen.com.
He was, maybe charged with making threats to use defensive violence, but no violence was ever actually used. And I want to point out, there are no allegations that any of the Brown supporters used violence in connection with this case, except one allegation in Texas that resulted in dropped charges. I want to remind folks, whatever their faults, the Browns apparently didn't use violence, while the federal government used violence on at least 6 separate occasions in order to bring this situation to a close. Now, it was a lot less violence than they could have used. It was a lot less than Waco, a lot less than Ruby Ridge, but they still used violence 6 times, and the Brown supporters used it between 0 and 1 times, depending on who you talk to. Of course, important also to remind everyone, the Browns did not attempt to force you and me to pay for their activities. The federal paramilitaries did force us to pay for their activities. Through the gas tax, the corporate tax, the income tax, the telephone surcharge, although I think that may have gone away, and any number of other hidden taxes that the federal government imposes upon the American people. The judge said Riley was not eligible for probation. His attorney, who he rejected, his rejected attorney's name was, I think, Mr. Weberg, but I never got his first name. After Danny's 15-minute long, rant or theorizing, whatever you want to call it, the judge began speaking, and he said, quote, he talked about the quote, need to protect the public from further crimes, unquote. The judge, I believe his name is Singal, I'm not sure if I'm saying that right, George Singal. He said, quote, he helped, judge said, quote, he helped string explosives on trees, unquote. The judge sounded like he was the accuser, as though he had actually been there and seen these things. The judge didn't say, there's overwhelming evidence that you strung explosives. He didn't say, the jury found you guilty of stringing explosives. He just said, you did it, as though he was there. And I found that to be troubling. He said that, and he made various other accusations against Danny. You did this, you did that, you did this, you did that, again, as though he was there and saw it. I'm guilty of the same thing sometimes, and that came up later in a conversation where I said something happened and I hadn't actually seen it myself. We're all guilty of that, but again, the government is the only institution they're the ones that are actually forcing you and me to pay them to say these things. I don't force anyone to pay me to say anything. And when it comes to saying that certain things happen that I didn't see myself, I am trying to change, trying to stop doing that and only report that something happened if I saw it. Otherwise, I should be attributing it. Hard habit to break. The judge said, quote, in my view, this defendant is a dangerous man. The judge also said, quote, this court will not permit such conduct to occur in society. Which of course is not accurate. The government cannot stop bad conduct or good conduct from happening in society. They don't have that much control. They can occasionally punish something that happens out there. Eventually, the judge sentenced him to a total of 432 months in jail. That was maybe 20 or so months less than what the prosecution had asked for. He's supposed to be, if he's even still alive when he's released, because that's 36 years, he would get 5 years of what they call supervised release. They spent a lot of time talking about the things he would not be allowed to do after he gets out of jail in the year, 2040 or whatever. This is nice. They said after he gets out, he's to be subjected to drug testing, not to exceed 72 drug tests per year. At that point, the prosecutor kind of gave backhanded confirmation of what I've just been telling you. I tell you about how what the judge had to say was so complicated. Well, the prosecutor didn't even understand the sentence and had questions for the judge about what the sentence actually meant. Another thing that the judge said that was complicated, hard to understand, he said Danny was he had a level 2 criminal history. I have no idea what that means. And I shouldn't have to know something like that in order to understand what a judge is saying. Is level 2 a lot of criminal history? Is it no criminal history? Limited criminal history? It could mean anything. The judge's demeanor was largely professional, but he did, do a lot of this, while Riley was talking. which, again, is relatively understandable because Riley was saying relatively strange things. But he was consistent, and again, he doesn't force you and me to pay for what he says. The government does that. Riley is not accused of using any weapon to hurt anyone in connection with this case, and yet the government is hurting someone probably at this very second with a weapon. Probably 10, 20, 50 people right now. It was interesting to note the contrast between the way the judge's demeanor was towards Riley and compared to his demeanor towards the prosecutor, Arnold Huftalen. I don't know if I'm saying that right, Huftalen. It's one of those two pronunciations, I think. The judge was very friendly, sort of buddy-buddy in his talk whenever he would turn and say something or ask something of the prosecutor. When he would turn around and talk to Riley, it was just, he was, again, professional but very terse.